This course is the Ellen F. Rose Supreme Court Plus More course, and we do think about Ellen F. Rose, who helped design it and who unfortunately died this summer. This course will address issues and cases that have not yet reached the Supreme Court, those that it's recently ruled on, and those that it may address in the future. The focus is particularly on the rights laid out or implied in the U.S. Constitution, their political context, and the potential for their reinterpretation by the Supreme Court. Last week, Ken Wald addressed religious freedom and separation of church and state. And today we have the honor of Professor Danaya Wright addressing the Equal Rights Amendment. And on October 27th, she'll explore academic freedom. So the title of today's lecture is To Be or Not to Be, Navigating the Technical Quagmire of the Equal Rights Amendment. Is that good enough?
That sounds good.
Danaya Wright is the Sessom Sohn Professor of Constitutional Law at the University of Florida Levin College of Law. This is her 25th year at UF, where her scholarship centers on the Equal Rights Amendment, regulatory takings, and constitutional history and amendment. She also writes in areas of real property law, trusts and estates, feminist jurisprudence, and theories of law. Professor Wright, take it away.
Thank you. So yeah, I don't want all the back stuff. Oh dear.
We have you here on the side. There's your Zoom audience.
That's
there.
my Zoom audience. Okay. Thank you all for having me. I just rushed over from a class that ended at 2:30, so I'm still a little frazzled and thinking about the elective share that I was doing in my Trust and Estates class. You're going to figure out how to make the slideshow?
Yep.
Perfect. I just want to say thank you for having me. It's a real honor to be here. I deeply miss Ellen, who just always had the best questions, and I know this is an issue that she would have been really interested in. And somebody made me provide a title like 6 months ago, so I don't know that the title is related to anything whatsoever, but I'm going to talk about constitutional amendment generally and the Equal Rights Amendment, which I think you all remember the Equal Rights Amendment. You may not realize that it has been ratified. But the issue of what we're going to do with it and whether the courts are actually going to recognize it is not as simple a matter as you might think. So as many of you know, the Articles of Confederation did not have an amendment provision in it. So well, I shouldn't say that. See, I'm already frazzled. The Articles of Confederation had an amendment provision, but it required unanimous approval by the states in order to amend. So when the new Constitution was being drafted, they put in a provision that allowed for amendment that did not require the full unanimous support. And I want to look at sort of how the Constitution has been amended, the various issues that have arisen, and what's at stake now with the Equal Rights Amendment. So first off, we have had over 2 centuries of constitutional changes. We've had 28 amendments. The first 10, obviously, were ratified in 1791. Then we had the 11th and 12th that came fairly quickly thereafter. 13th, 14th, and 15th Amendments. It was 65 years after the first 12 amendments before we get to the next set of amendments, the Civil War era amendments. Then we had 16th and 17th Amendments. It's the 20th century before we get to the 16th and 17th Amendments, establishing the income tax and popular vote for senators. Then we had a whole slew of amendments during the Progressive Era, New Deal, dealing with prohibition, women's rights to vote, ultimately the repeal of prohibition. And then we have another series of amendments really coming in later. I consider these more civil rights era amendments, the 22nd through the 26th Amendments. A lot of them were structural amendments. Finally, we had the 27th Amendment, which I'm not sure you're all familiar with the 27th Amendment. It was one of Madison's original 12. that was proposed as part of the Bill of Rights. And some states had approved it back in 1790. Some other states randomly approved it over the 19th century. And then there was a push in the 20th century to ratify that amendment. And it finally was ratified in 1992. And of course, the 28th Amendment was ratified in 2020. So if we think about the constitutional changes that we've had, they tend to fall in, I see them as 4 clusters, 4 time zones. So the first era really came about at the founding. And then we have these periods which is a period of profound sort of social and political change. And then we see that again in the Civil War era, where we get another cluster of amendments, then another cluster of amendments during the New Deal, Progressive Era New Deal, and then another cluster of amendments during the Civil Rights Movement, sort of the 60s and 70s. So the poll tax, the 18-year-old right to vote comes in there. The congressional one, that's sort of a funky one. So when we think about the Article 5, most people don't, you probably don't think about Article 5 very often, and most people probably don't talk about Article 5, the amending clause, but it is a really interesting, very, very short provision of the Constitution. It has 3 parts in the 70 words that matter. It originally, when the amendment was first proposed, or not the amendment, the article was first proposed, it was going to simply provide that the states could propose amendments and then the states would ratify. So there was no role for the federal government at all in the amending process originally, because it was seen as the Constitution is an assembly of states. These parties, they're parties to the Constitution, they can amend the document. Hamilton is the one who suggested that maybe the members of the federal government, Congress, would be more likely to kind of know what's wrong, how it's not functioning well, and that Congress should also have the ability to propose amendments. But they left it as only the states can ratify. So the final version of Article 5 allows, as I say, it is in purple, the Congress or the states can propose. They need 2/3 to call a convention, or 2/3 to propose an amendment. Then in blue, we have ratification is a function that solely resides in the states. And then a determination as to whether the states will ratify by convention or by legislature, through their legislatures, is a function that solely resides in Congress. So there's 3 powers under Article 5, the proposal power, the ratification power, and the mode of ratification power. The proposal power is split. It's shared jointly between them. The ratification power exists only in the states, and the mode of ratification power exists only in Congress. And this is really, really relevant, okay? So there are really big gaping holes in Article 5. Easily drive a few trucks through them. So, for instance, do both houses of Congress have to pass a proposal in the same year? Right? It says Congress has to propose 2/3 of the houses of both houses of Congress, but does it have to be the same year or the same Congress? There's nothing in the Constitution that says that they have to do it in the same decade or even the same century, because most constitutional amendments are proposed in one house and passed and not in the other. And then 20 years later, the politics change and that house passes it and the other house doesn't. But the general rule that Congress has come up with is you've got to do it at least in the same Congress. So within the same 2-year period. Do the states have to follow a certain procedure for engaging in this federal process of amendment ratification? For instance, do they need a supermajority? Do they need a supermajority of those present? Do they need a majority of those present? Do we need the governor's signature? Do we need a public referendum? Can they be constitutionally required to ratify, or can they be precluded from ratifying? So a number of states in the 19th century put in place constitutional amendments that prohibited their legislatures from ratifying constitutional amendments that would expand the franchise. They were trying to preclude the 15th Amendment, and ultimately tried to preclude the 19th Amendment, giving women the right to vote. And those were those constitutional provisions in those state constitutions were ultimately held to be void. Can a state constitutional amendment limit the legislative process of ratification? So in other words, think about Article 5, those simple 70 words. Can a state, for instance, pass a constitutional, the people of the state pass a constitutional amendment that says, hey, Florida legislature, you can only pass this kind, ratify this kind of amendment, or you must ratify the Equal Rights Amendment, or the DC Representation Amendment, or you cannot ratify a certain kind of amendment. None of that is open, and yet all of these issues have arisen in the past with regard to constitutional amendments. Can Congress impose ratification requirements? In other words, think about that language. Let me go back. The red, as the one or the other mode of ratification may be proposed by the Congress. So Congress has the ability to say, states, you got to do it by convention or you've got to do it by legislation. Can Congress say, well, you got to do it within 7 years, or you have to do it, you have to have a supermajority, or you have to have a public referendum. Your legislature can't just do it on its own. All these questions are wide open, and they've all arisen in prior constitutional amendments and never been resolved, or almost all of them have never been resolved. So in 1920, so the idea behind the Equal Rights Amendment, I'm going to use the Equal Rights Amendment to sort of show you how sort of all of these problems have arisen in the context of the ERA. So the 14th Amendment guarantees equality, equal rights, equal protection of the law. And the court in the slaughterhouse cases said that that equality right applies only in the context of race. And then the 15th Amendment grants the right to vote, or you can't deny the right to vote on the basis of race. So the 14th and the 15th Amendments are this pair that gives voting rights and equality rights on the basis of race. So women back in 1865 were arguing that the 14th Amendment, when it eventually got ratified, that included women. But the Supreme Court said it didn't, that it applied only in the context of race, that the 14th Amendment equality protection was only a race-based provision. So then in 1920, we of course affirmed or ratified the voting rights for women, right? The 19th Amendment that gave women the right to vote. But they didn't get the Equal Rights Amendment that went with it, right? So, and it was planned as a two-stage process. We did it on the basis of race with the 14th and 15th Amendment, and we anticipated it was going to be the 19th and 20th Amendments were going to be the ones for gender, sex-based discrimination. So in 1923, Lucretia Mott, the first Equal Rights Amendment was proposed in Congress to follow right on the 1920 ratification of the 19th Amendment, giving women the right to vote. And it was very simple. Men and women shall have equal rights throughout the United States and every place subject to its jurisdiction. Congress shall have the power to enforce this article by appropriate legislation. And that amendment, or some version of it, was introduced into Congress, at least one house or the other, every year for the next 49 years. It took 49 years. Finally, in 1972, this is what came out of Congress. And it came out only because of a technical little manipulation that was done. But I want you to look at the Equal Rights Amendment. It has two parts. Well, actually, it's four parts. But the first part is called the preamble, or the resolving clause. And that's the clause that says, resolved by the Senate and the House, 2/3, that the following article is proposed as an amendment to the Constitution. And it says, when ratified by the legislatures of 3/4 of the several states. So that preamble is Congress exercising its mode of ratification power and saying it's going to be by legislature, not by convention. But they added those last 10 words, within 7 years from the date of its submission by the Congress. This is the second time in our history that we had a deadline imposed by Congress on the ratification function of the states. Then we have our 3 parts: equality of rights shall not be abridged, Congress has the power to enforce, and then this is important: this amendment shall take effect 2 years after the date of ratification. So the 2-year point is really important for where we're at now in terms of litigation on this. So, I think, you know how Congress is, that, we can't make this happen right away, right? And the reality is, once an amendment is ratified, it immediately becomes effective, right? It's immediate. So once the last state ratifies. So you've got to have states, you've got to give states time to bring their laws into compliance. Now, the logical answer is you should have been in compliance before that, or you should have seen the writing on the wall and gotten yourself into compliance so that when the amendment is passed, but it was really to give states the chance. I think 2 years is longer than they need, but what can I say? Okay, so when we look at what happened in March of 72, the amendment came out. In year 1, within the first year, 30 states ratified it. We needed 38 states. Year 2, 3 more states. Year 3, 1 state. Year 5, 1 state. March 22nd, 1979, that original 7-year deadline expired, and we only had 35 out of 38 states had ratified the ERA. Momentum had stopped. Florida was well, not yet. They eventually get into it. On June, sometime before March of 79, Congress extended the deadline by 3 years and 3 months. And 3 months. And it was very controversial. Very, very controversial. They thought that's not fair. A bunch of states that had ratified said, hey, they had changed their minds. They were getting a lot of pressure to back away from the amendment. And so a number of states took that 3-year extension as an excuse to try to rescind their ratifications. Year 45, Nevada ratified in, 2018. In 2019, Illinois ratified, and finally in 2020, Virginia ratified. So it took 48 years for the states to ratify. And those last 3 states ratified despite that 7-year deadline. And their argument is, Congress, you don't have the authority to impose that 7-year deadline. It's not it's ratification resides in the states. Article 5 says it. You cannot impose that. But of course, we're going to have to litigate that issue, right? We're going to have to litigate it. But I do think it's important that it took 49 years to get the ERA out of Congress. And it only took 48 years to get it ratified by the states. So while they talk about how, we are so far past that 7-year deadline, but the reality is, it took Congress longer to get on the ball on this subject. Okay. So during that period from 1979 to 1982, 5 states rescinded or sunsetted their ratifications. So Nebraska, Tennessee, and Idaho vote to rescind. Kentucky votes to rescind, but they only have a simple majority. And their legislation, their legislative rules require a supermajority. So Kentucky had a supermajority when they ratified it. We're required to have a supermajority when they ratified the ERA, but they rescinded with only a simple majority. Query, is that legitimate? Can they do that? Does Article 5 say anything about that? No, because Article 5 has gaping holes in it. South Dakota, I like South Dakota, it passed a joint resolution after it had ratified to say, we meant to sunset our ratification as of the date of the original deadline expired. They did this after the fact, right? So they ratified it, they did it after the fact. North Dakota in 2021 after Virginia has already ratified, and we've already hit 38 ratifying states, depending on what happens with those 5, they voted to retroactively clarify that their 1975 ratification was really only valid through 1979. I mean, it's the manipulation is really kind of interesting that states are doing here. So there's 2 major issues with regard to the validity of the ERA. The first is that deadline. Does Congress have authority under Article 5 to impose a 7-year deadline on the states on that sole state ratification function to limit them to 7 years? And the second is, are these rescissions valid? Can the states rescind, sunset, or retroactively constrain their ratifications? I think clearly the answer is no after the amendment has been ratified. But could they rescind before the full set of ratifications have happened? So what do we know about the deadline, the legal issues regarding the deadline? We know that there were no deadlines imposed in the first 17 amendments. The first one, the only one, well, not the first, the first one was added to the 18th Amendment by then Senator Harding to kill prohibition. He thought, there's no way I can vote to put forward the Prohibition Amendment, but there's no way it's going to get ratified in 7 years. So I can look like I'm a dry, but I'm really a wet. And so I don't, I can just, he was hoping to, it was all just a political move, to torpedo the Prohibition Amendment, and it failed. The 19th Amendment and the Child Labor Amendments, the child labor was never ratified, but those 2 had no deadline. So it was really, the 7-year deadline imposed on the 18th Amendment was really put in place just to kill that one amendment because it was so controversial. And it has remained controversial throughout our history. The 20th, the 21st, and the 22nd Amendments, however, they added deadlines to the text. They added a provision at the bottom that said, this amendment is not valid unless it's ratified within 7 years. Now, just think about that for a minute. The amendment itself does not become valid until it's been ratified. So if you ratify it after the 7 years, now it's ratified. Now that provision becomes effective that then causes it to self-explode, self-destruct. So it's this interesting self-destruct button. And they figured out that logically that really didn't make a lot of sense. So after that, they moved that deadline to the preamble. In the 23rd, 24th, 25th, and 26th Amendments, they're in the preamble. Now, every one of those, the 20th, 21st, 22nd, 23rd, 24th, 25th, 26th, all had deadlines, and they were all ratified within the deadline period, within the 7-year period. But the ERA was not. The Child Labor Amendment had no deadline. The 27th Amendment obviously had no deadline, but it took 200 years for it to be ratified. So after the 27th Amendment in 1992, people started saying, wait a minute, what's the 7-year deadline all about? If we can ratify after 200 years, states can ratify, why can't they ratify after more than 7 years, after 8 years or 48 years, as the case may be? The DC Representation Amendment proposal, interestingly enough, was being proposed right about the, it's never been approved, it's never been ratified, but it was being proposed during the debate over the ERA extension. So they put the deadline back in the text rather than in the preamble, because there was a concern that the preamble could just be changed by Congress, which is why ever since 2019, actually I think prior to 2019, there have been proposals in Congress to remove the deadline from the ERA. If you could extend it, we could remove it. So that's a very live issue right now with regard to the ERA and the deadline. Okay, so legal arguments about these deadlines. Are these legal arguments, are there any good legal arguments as to whether the deadlines are any good? I happen to fall on the side that the deadlines are unconstitutional. So I've got more against than for, but I think there's a real concern here that Congress is overreaching into the states, a state function, when they limit when the states can ratify. Now, they have absolute control to say, you legislature or convention, but when they say you got to do it within 7 years, where do they get that power? I think that's a federalism concern. I think there's also the fact that the preamble is not part of the text that gets ratified, right? What gets ratified and what ends up in the Constitution itself is actually the text, not the preamble. The preamble is where the deadline is. Why can't we just delete the preamble? Or as Justice Scalia said when he was interpreting the Second Amendment, the preamble is not relevant, right? In order for a well-regulated militia, the right to keep and bear arms, he said, well, that well-regulated militia, that's not binding on anything. Okay, well, preambles are not binding. 7-year deadline, not binding. Frankly, 7 years seems a really short time when we look at other constitutional amendments. I mean, most constitutional amendments have been ratified in less than 7 years. But when we think about the constitutional amendment process, Congress spends an awful lot of time lingering over these amendments. Why not give the states that same amount of time? So if you were just to look at Article 5 and ask yourself whether Congress should have, this is sort of just a technical detail about running constitutional amendments, 7 years reasonable? And then there's a complicated question of whether Congress's Article 5 power is even an issue. The interpretation of whether it exceeds or does not is even justiciable by the courts. Right? Is this actually an issue, a case or controversy kind of issue that a court that falls within the jurisdiction of the courts? So in support of deadlines, unfortunately, we do have a Supreme Court decision, but the Supreme Court decision is a funky one. It was a challenge to prohibition where a guy was arrested. Literally, I think prohibition had a 1-year sort of waiting period until it kicked in. Statute went into play immediately after that 1 year, and somebody was arrested for running booze. And he said, well, the deadline is unconstitutional, therefore the Prohibition Amendment is void. And the court said, well, no. I mean, it was ratified by the number of states. You can't say that just because it had this really ineffective provision, because that provision never kicked in, you can't say that that's sufficient to void an otherwise properly ratified amendment. But it kind of this case gets used as though it should be able to operate, that 7-year deadline should be able to operate to stop the amendment itself. Another argument has been made that Congress has these Article 5 powers to make proposals and dictate the mode of ratification, and putting a deadline is surely within one of those powers. Question whether it is. And finally, the deadline issue is a non-justiciable political question, and really we should leave it to Congress. Now that, I hope you recognize, is a dangerous argument. Congress oversteps its bounds, and then we say, oh, that's a non-justiciable issue. Congress, you get to decide if you overstepped your bounds. That's not a good one. All right, legal arguments on those rescissions. Where are we on the rescissions? Against rescissions, and this is all up in the air. These are the issues that are being litigated right now with regard to the ERA. No state has ever been permitted in the past to have their rescissions count. They have attempted to rescind, but when they did, a bunch of states tried to rescind the 14th Amendment, but enough other states ratified, so their rescissions didn't matter. But ultimately, they get listed as having ratified, like in the official list of states that have ratified, states that tried to rescind, but they didn't matter. I think there's a good argument that rescissions would destabilize the ratification process. So imagine you're Florida and you're thinking about, are we going to ratify the ERA or not? And Georgia, no, that wouldn't happen. I don't know, Ohio says, oh, darn, we've changed our mind. Let's rescind. And now Florida won't be able to put it over the line. And you're a Florida legislator thinking, do I want to spend a lot of effort, political effort on this constitutional amendment? And the other states are pulling the rug out from under you by rescinding however they want. And of course, Article 5 only uses the word ratification. It's kind of a one-way street. States can ratify. Nothing in Article 5 that says they can rescind. In favor of rescissions, though, the argument has been put forward that, well, if ratification is a power, they should also be able to rescind, at least up until the amendment is fully ratified. And there's a funky argument that rescinding is a power never ceded to the federal government, right? If we think about the Constitution, it's about powers given to the federal government by the states, and the power to rescind or to control rescission was a power that they never gave up. They still have it. And finally, they argue that rescission is a non-justiciable political question. We should leave it to Congress. So what's the paradox of Article 5? Is it self-executing, right? There's nothing that says, okay, 38 states have ratified, now what happens? Does anybody have to publish it? Does anybody have to say, you know, does it just immediately come into existence? Can the states establish their own rules, right? Can they make these supermajorities? Because some of the states, Illinois, ratified the ERA back in the 70s with a regular majority that would have been sufficient under most state law, but they required a supermajority. Their own legislative rules required a supermajority. And then, you know, states vote to ratify. Oh, I got to tell you about Tennessee. So when Tennessee ratified the 14th Amendment, well, they were told they had to ratify the 14th Amendment if they wanted back into the Union. They took all the senators or all the legislators who were going to vote against the 14th Amendment, and they arrested them, and they held them under house arrest, and they did not allow them to vote, but they counted them for quorum purposes. So they were able to get the vote over the line by arresting these guys. So, you know, there's a lot. These questions have come up. Often the Secretary of State just certifies, says, "Oh yeah, all right, we've ratified this amendment." Does the governor have to sign those? Some governors have, some haven't. How do we know? Right now, the National Archivist, who I would not mess with the National Archivist, right? You don't mess with archivists. The National Archivist is the person who receives the certificates of ratification. And the courts have said what the archivist does is just count them up, tally them up, you know, that they are presumptive that the state has followed their own procedures. The archivist does not get to look behind the certificate and ask, did the state follow its own procedures? However, the prior National Archivist, we've got a new one now, is refusing to publish the ERA, even though that archivist has received 38 ratifications. And can Congress require a particular state procedure? All of these are giant questions that are raised by the ERA that are completely left open. So we have very limited judicial precedent. We know the president has no role. We know that an ineffective deadline does not void an otherwise validly ratified amendment. We know that a state may not impose additional burdens on ratification. There were some states that had like public referendum requirements. They can't do that. And we know that a state's ratification certificate is conclusive that the state followed its own procedures. That's the only precedent we have to answer these questions as to whether or not the ERA is a validly ratified amendment. So where are we? We're in litigation. Virginia, Illinois, and Nevada sued for mandamus to require the National Archivist to publish, to promulgate the 28th Amendment. 5 states, at least three of those, I think, are states that had tried to rescind. They moved to intervene. The court allowed it. On March 5th, 2021, the judge dismissed the lawsuit on the grounds that the archivist was not the right person to sue. But who are you going to sue? You can't sue Congress because they have no role. You can't sue the president. The president has no role. You can't, who do you sue? We spent a whole lot of time going around and around and around on who in the world you would sue if the archivist refused to put it forward, which the archivist has done based on a Trump era Office of Legal Counsel memorandum saying, oh, yeah, that 7-year deadline, that's fine. But in order to litigate whether it's fine, you got to have someone to sue. But they said, no, you can't sue the archivist. So on appeal, a bunch of ERA groups filed in January 2022, but Virginia's Republican AG, Virginia being the last state that put the ERA over the line, they pulled out of the lawsuit. Oral arguments have still not been set. And in May 2022, last May, the Elizabeth Cady Stanton Trust filed separate lawsuits. What they're basically doing is they're looking, they had to wait till the 2-year period elapsed. And then they could say, okay, this state has not, is not in compliance with the ERA, and my private rights, so private citizen suits are what's going to go forward in the context here. Because this archivist suit didn't work. So where are we now? I don't know. As of January 27th, I think the ERA is arguably valid. It has met the technical requirements of Article 5 and the 2 years have elapsed. And any litigation over its validity likely requires this private citizen suit with appropriate standing. But there are suits out there being litigated right now, and I think it's going to end up before the Supreme Court. And with Ginsburg on the court, I was going to say it only took one judge. We only need one conservative judge, and I think there's a number of them that would agree that the deadline is an overstep of Congress's power, right? If they're all about states' rights, they're all about limiting congressional power, there's a really good argument that Congress overstepped when it imposed that deadline. And this is the only case where we have had ratification after the deadline. You couldn't challenge it if the ratification happened before the deadline because it was ratified. The deadline was ineffective. This is the only situation where we have that 7-year deadline killing an amendment that's otherwise properly ratified. And I think that's it. Yep, that's it. So thank you.
Open to questions either online or in the audience.
So who is the private citizen who has appropriate standing?
It would. So I was really hoping it was going to be the U.S. women's soccer team, right? That it would be some woman or man who could claim that a state, say Florida, has a law that is unconstitutionally distinguishes between on the basis of sex, and that person is injured by the existence of the law. So I could see an Equal Pay Act kind of claim, arguing that the states need to get on the ball. It could be, I think, a really good case would be the 18-year-old young man who has to register for the draft, who says, this is unconstitutional, that you're not making women register for the draft too. And by having it be a man bringing the suit, it shows that the ERA has, applies to everybody. But it's got to be a personal injury of some sort, that the law is allowing someone to be injured. That's
other comments or questions?
That could be why they did away with the draft. I happened to be in the Illinois legislature at the time that this was being voted on.
Wow.
We were there as a group in support of the ERA. We were also sharing the hotel with Phyllis Schlafly and her group of the Eagle Forum. And
Yep.
she was delivering cookies and baked things to the men in the legislature while we were only trying to discuss on an intelligent level.
Yes.
However, the head of the Senate, we thought we had it, and we did have it in terms of majority. But the head of the Senate, just before they were going to vote on the ERA, moved for procedural change. And he went from the simple majority to 2/3. We didn't have that vote. They passed that vote, and then they voted on the ERA.
Oh, interesting. So they
So
had the votes to impose a supermajority. But wouldn't it have taken a majority of votes to impose that? And if you had a majority in favor of the ERA, why would any of those people vote to impose a supermajority requirement?
Well, obviously, they had a plan before we even got there.
It's politics, right? It was the exact same thing that Warren Harding was doing with prohibition.
Right.
Was I'm going to put this little 7-year deadline in, and I get credit for having voted for prohibition, but I really don't want it to pass, right? I think that's really interesting.
Great. Other comments or questions?
Anybody here on Zoom? Any questions or comments?
I do have a question, and I've always been concerned about the U.S.'s role in ratifying the UN treaties,
Oh,
of which we have very few ratifications. But do you know whether the UN accepts retractions or rescissions of ratifications?
I don't know. That's a really good question. Right? I mean, the term ratification is very different from the term, passing in legislation. So if we know that legislators vote to pass, this year they all, you don't quite have the right number of people, of votes to pass a piece of legislation. You keep working on it. You eventually get the right number. And, down the road, you may get enough votes to rescind, to remove or to alter legislation. That's not ratification, right? I think the term ratification is a very different term, and it implies a very different function that is really a one-way function. Once you've ratified it, that's it. You don't get to change your mind. Yeah, and that's what was determined with prohibition, right? So as soon as prohibition was the craziest thing to happen, right, constitutionally, it really was a very unusual, and I think, a lot of people didn't expect it to pass. It's kind of like the dog that catches the car. And suddenly you've got prohibition and people are like, oh my gosh, this was a really bad idea. And there was a lot of litigation, a lot of legal challenges, went to the Supreme Court on the 18th Amendment. Other amendments have never been challenged, but that one got a lot of challenges. And over and over, there were articles that came out that said, oh, well, this is not the kind of subject you can pass a constitutional amendment about, therefore you don't have to follow it. And the court said, no, you got to follow it. And so that's why eventually it had to go to a repeal amendment. So I think the ratification function, it is one way. I think the ERA has met the technical requirements of Article 5. There's no question about that. The only thing in the way are the rescissions and the deadline. And I don't think the rescissions are valid because, we couldn't rescind prohibition. People tried to rescind the 14th Amendment. That was not given any weight. And so the question is, what about that deadline? But that just strikes me, going back to the language of Article 5, as being completely beyond Congress's authority to impose a deadline like that. So I think that's a really good question. I don't know the answer about ratification of other types of actions, but I think it's a very different action.
Right. Other questions or comments?
Roy over here has one.
Right.
Well, with the UN or with the international commitments, the Senate has the role of advice and consent, but even though they advise and consent, the president is not obligated to go forward with it. So the president wasn't obligated to go forward with accepting the obligations of the UN, I don't think.
I think that's right. I know the Senate is not binding, but Congress then comes along and passes legislation afterward to effectuate treaties, but that they're not necessarily binding unless Congress passes laws to make them binding or the president chooses to comply. But I do think that's different. I mean, I think the constitutional Article 5 process, we've had 27 amendments, 28 amendments, depending how you count the ERA. There's only 4 amendments out there that are potentially lingering. And they really don't have any, they're nothing we should be afraid of. Although there is one amendment, the Corwin Amendment, that provides that slavery shall never be abolished. That was put in just before the 13th Amendment. It was sort of the contrary one. And a couple of states ratified that one, not very many. But I mean, it doesn't have a deadline. Presumably it could be ratified, but I can't imagine it ever would. The Child Labor Amendment has never been ratified, but the Supreme Court backtracked on its position, and we have a child labor laws. The DC Representation Amendment has not been ratified. It does have a 7-year deadline, so it could be in the same boat we're in with the ERA if people got really motivated. But great. I mean, that one doesn't bother me at all. And then there's some amendment about, is it no titles of nobility, something like that. There's one, I think, that might be lingering that's not really worrisome. So this idea that we have to sunset these amendment proposals because they could come back to bite us 20 years, 100 years from now or 200 years from now, I think that's a weak argument because if the states decide it's time, then it's time. The states got fed up with Congress and it's their pay, always, voting themselves a pay raise as they were leaving town. That's why the 27th Amendment was finally ratified, was states said after 200 years, we're sick of this. And I don't see why the states can't say the same with regard to the ERA.
What is the actual status now of the DC?
It's got some ratifications. I want to say it's not a huge number, like 12, 15. We're nowhere close to the 38. I mean, the ERA got to 35, and then it petered out, thanks to Phyllis Schlafly. Although some people say it wasn't Phyllis Schlafly. They'd say it was petering out anyway. It was never going to get over that. But, Florida almost got it over, I think, in 1981 or 82. I think it was 82, just before. It finally sunsetted. It was up in the Florida legislature, and Martha Barnett was really pushing on that one, but it failed too.
I have another question. Just in terms of strategy, a number of organizations are trying to avoid the Supreme Court because of its current makeup.
Yes.
And it's demonstrated potential to make up facts in order to determine its decisions.
Yes.
Is there a workaround through the Congress?
So yes, so there's a number of things are all happening at once. So we obviously have litigation on the 38 ratifications we have. There's grave concern that the Supreme Court, ideologically, the 5 justices are probably opposed to it. The 6 conservative justices are opposed to it. On the other hand, they're the ones that are constantly spouting textualism, originalism, states' rights. So they're in the position that if they're going to follow their principles, they need to affirm the ERA and affirm the states' rights to ratify. The liberals are all going to be in favor of it because they like the outcome, right? So, we're going to need a couple of conservative votes to go to get. So that's the Supreme Court route. I feel like it's the arguments. If they are true to their principles and their theories, it should pass. They should affirm the ERA, the conservatives on the court. So, but what the heck, you never know. So there is legislation proposed in Congress, and it's been proposed every year for the last 4 or 5 years to remove the 7-year deadline altogether. There's also proposals in Congress to just start over. But I don't know that we'd get 38 state ratifications right now if we had to start all over again. But the proposals do keep coming forward. But you can never, like the Senate's not going to do anything about that. What other, I think those are the 3 strategies we're at right now. And the 4th strategy is really, I think, to put pressure on the Biden administration and his Office of Legal Counsel to instruct the new National Archivist to go ahead and at least promulgate, recognize it, publish it in the federal record, and then let the states that don't like it oppose it. It's a better position to be in than to be in the position where you want it to happen and they're blocking you.
I have a hypothetical question, really, but I'd like you to think about this. What? Too loud? Too loud? Can you hear me?
I can hear you.
Okay. Suppose the ERA had passed. It was now part of the Constitution of the United States. Could Roe versus Wade be overturned if it had already passed?
I think that's an outstanding question because I really do think with an ERA, it would have been a lot harder to overturn Roe, right? So Roe was sitting on a very vulnerable foundation under due process, the due process clause. And New Mexico has an ERA in its constitution, and its state Supreme Court, admittedly, they're a liberal state, but their state Supreme Court has come out and said, absolutely, abortion is an equal rights issue, and that women cannot function equally in the workplace unless they have reproductive rights. And they held their equal rights amendment, or equal rights provision in their constitution would require that abortion be allowed. So I absolutely think that if we can get the ERA recognized, really good argument that these state laws are unconstitutional under the ERA. I think that's a great question. I absolutely. We got to do what we've got to do, do what we can.
Great. Thank you so much.
You're
It's
welcome.
been a
Thank
really,
you.
really interesting discussion.
Thank you for having me, and I hope that wasn't too much constitutional technical nitpickingness.
And we look forward to seeing you in a couple of weeks.
That's right. I'll be back. And thank you all for coming at 3 instead of at 1 or 1:30, whenever the usual.
That's all right.